I have done research on the top 10% plan up to the point where the Grutter decision was made, so not the 10% plus, which takes place 2003 after. I am a UT grad. I did my PhD at UT, but I didn't have a dog in the fight when I was doing the research. So that is a sort of background and disclaimers. I think it's a very sad day for social justice when mortality is a pivotal vote in the Supreme Court decision. I'm on record expressing my surprise about the decision in support of the University of Texas, although quite gratified. There was a good deal of speculation about the second Fisher decision, and it was mostly pessimistic. That's what the news coverage was all about. Because views of supporters and detractors in the divided court were mostly known. Alito, Scalia, Thomas, and Roberts were against a race, period. And it's evident in the kinds of questions they asked in oral arguments. Ginsburg, Sotomayor, and Breyer in support, and Kagan recused. This was an unlikely decision for Texas. The numbers, you don't have to be a math whiz to see what was going. And also there was no conflicting appeals court rulings to justify this reconsideration of the case, the same case in a very short period of time. What is going on? The signs were not encouraging. Fisher 1 remanded on procedural grounds, as we know, for not applying strict scrutiny, allegedly. Fisher 2 is just but another chapter in this expanding volume of affirmative action in college admissions that the Supreme Court has been writing since Bakke, which outlawed quotas. And whose quota, what quotas, and how you design quotas, that's all been up for grabs. The Gratz rule assignment of this extra credit for race is unconstitutional. Grutter reaffirmed that narrow tailoring was possible within the context of holistic review. So the critical mass rationale was swirling around. Nobody could get their hands around it. It was argued that it's really important, and it remains a challenge in oral arguments, and it was in the earlier one. We can't define it. We know it when we see it, presumably. And we can describe it anecdotally. But as a principle for making decisions and arguing that this is what we're trying to achieve and this is how and why we're capitalizing on diversity and leveraging it for educational missions, well, we know. We've given examples. And examples were quite different from the hard facts that seem to be really important in some of these decisions. So this still does remain a challenge in arguments. But let's be really clear. Abigail Fisher was not admissible to UT any more than Cheryl Hopwood was admissible to the UT Law School. And that's what led the UT decision about the law school about Cheryl Hopwood, which was a class action of an unemployed lawyer who, as a dear colleague of mine from UT described, well, he was unemployed, all he needed was some stamps, stationery to organize. Have you been discriminated against? Sign on, and I'll take it from here. But she wasn't admissible. What was interesting in that case is that it was a law school admission decision like Grutter, but the solution was a 10% plan for undergraduates. They didn't touch the graduate school admission. What's wrong with that process? And the Attorney General at the time, Morales, said, oh, it applies for financial aid, it applies for everything. We're going to exclude in every possible way, and that was working. So everything plummeted. But that is not why Fisher's rejection was litigated all the way to the Supreme Court, because she was inadmissible. Understanding college admissions post-Fisher requires acknowledging that the political forces that will reemerge to challenge race-sensitive admissions now and in the future. That were a political orchestrated effort to do so, not Ms. Fisher per se, because she didn't have the resources to litigate, and she litigated individually. No, she didn't. She lent her name. At highly selective institutions, the majority of applicants are denied admission. We're down to less than 10% of like 6% in many of the most selective private institutions, and that's a fact. Prior to this litigation, Texas had an admission rate, it was 50, 60, 70%. Almost everybody that was in the top 10% of their class was admitted. 95 to 93, 95% of top 10% graduates who were granted admission prior to this litigation. All it did is make it visible and make it an official criterion. So by making it an official criterion, then it comes into sharp relief, because the admissions officers knew that performance is a much better predictor of success in college than test scores. They knew it. Everybody knows it. I told the College Board. They know it too. They admit it, but they just don't advertise it. That's a fact. I'm not kidding about face-to-face. You probably know that. I would do that. Relatively few aggrieved applicants actually sue, even except for those that agree to lend their names to a well-funded and politically orchestrated initiatives to end race preferences. Narrowly tailored or not, strictly scrutinized or not, the goal is to end race preferences once and for all, period. End game is ending them, full stop. But even before Fisher II decision, I was contacted by lawyers representing UNC because the same organization that supported the Fisher litigation filed complaints against the university. A similar lawsuit was filed against Harvard. The novel twist here, and if 10% was one of the novel twists in Texas was low-hanging, now it's that Asians are the aggrieved class, presumably because they face ceilings, higher standards as a condition of admission than non-Asians. That may be the next chapter in the future edition of the affirmative action volume that the courts are writing. Or it could be the top 10% plan. That may be the focus of the next chapter. I was surprised to read in the opinion that, quote, percentage plans are adopted with racially segregated neighborhoods and schools front and center stage. It is race consciousness, not blindness to race, that drives such plans, end quote. The reason I was surprised to see it in Fisher II is because in Fisher I, they were trying to downplay the underpinnings of segregation, and we actually wrote a paper about that when I was analyzing some of the administrative data. So in refuting the plaintiff's claim that percentage plan was race-neutral alternative initially, or in some of the discussion at the lower courts, the court acknowledged that it works because of segregation in the Fisher II, explicitly. That's there. And this is something, the paper we wrote about, capitalizing on segregation, pretending neutrality. And what's important is that we actually showed that the probability of being admitted in these highly segregated schools was lower for minorities, if you look at a probability, rather than just the fact of sheer numbers. Probabilities and rates matter. It matters for understanding, is this actually improving circumstances and admissions behavior? The same logic has been used by Lino Graglia, who's a UT lawyer, very anti-affirmative action. He declared once these decisions are, once we end race preferences, we've got to take down the 10% plan because it's not race neutral, even though it says so. So once the issue, for him, it's settling this race preferences issue. I guess his timeline's been changed. The percentage plans must be eliminated because they are predicated on race. All right, so that could be the next chapter. So where's the silver lining? It's not in the reference to critical mass, which remains problematic in legal arguments because it defies precise definition. We know it when we see it. But this core premise upheld by Grutter may be increasingly problematic because it will be ever more difficult to define a critical mass in an increasingly race-diverse, pluralistic society. And our campuses are becoming more diverse gradually, slowly. So what's the critical mass over time as campuses become more diverse? College climates. There is a silver lining, I think, that top 10% would not have been passed had Hopwood not sued the UT Law School. And since 1998, UT has enjoyed greater diversity in its geographic diversity in its student body. Irma Rangel, who served on my advisory committee at the time, was very clear in arguing before the Texas legislature that the goal was to have the universities, the public universities, supported by public taxpayers, to represent the state. Socioeconomic grounds, geographically, and race. But the only one that got play is race ethnic diversity. The socioeconomic was really important because Texas is so unequal. And the geographic is very important because 28 schools out of 1,500 were filling a quarter to 20% of the classes at the two public flagships. I mean, what's wrong with that picture? So the big impact was geographic diversity at UT, not at A&M, because it's a land-grant school, and they were having trickle in from this school and that school and the other by design. So Rangel's vision is something that has been put on the side, although it's happened almost by default. The biggest impact was geographic initially. And let's be clear about the ties between the top 10% and ethno-racial diversity and income diversity at UT campus. What happened is enrollment rates of the top 10 Black and Hispanic students admitted to UT, the flagships, were actually lower under the top 10% plan compared to the period before the admission guarantee was used. And the reason is that the denominator, the number of the applicant pool, increased. Texas population is growing so fast during this period, it got 4 congressional seats in the last round of the census. It's a demographic phenomenon. The denominator is getting bigger, so to actually look at, oh, we're getting more diverse by looking at composition, misses the point about the rate of the probability of getting admitted. What's more, application rates of the top 10% graduates from the poor high schools remained well below those of lower-ranked graduates from the affluent schools. Application rates. Who's focusing on who's not applying? I know it's a hard question, but if we can't get those application rates up, we're never going to get the admission rates up, and we will, and that's what Washington State has done, is try to just get people to apply. When you get a much more diverse pool, guess what? They're going to trickle up. You're going to find the aristocracy of talent in the larger masses. So this is something that not a comforting picture if we really care about access, and especially equalizing along all these dimensions. Even at high schools where 80% of the students' body is black or Hispanic, white students are significantly more likely to qualify for the admission guarantee than their black or Hispanic counterparts, again illustrating the power of social class. One only needs to visit some of these high schools in South Texas, and you see all the books for the SAT. I said, what are they doing here? They go, oh, students can check them out. Go to Princeton University in that community, and all the parents are hiring tutors at $25, $30 an hour to prepare their students for a class. Big difference. Our math and science teachers have PhDs. There, I said, who teaches AP here? Oh, they go to UT Austin for 2 weeks in service. That's the competition. Texas could remain a propitious target for the next chapter of affirmative action. It's rapidly becoming majority-minority, more competition. Public high schools are becoming increasingly segregated by income and race and immigrant status, more top 10 eligible. Growth in college slots have not kept pace with the rise in college-eligible students as high school graduation rise. So the college squeeze intensifies in Texas, competition again. Texas has underinvested in higher education state funding, and guess what? State support for higher education has fallen, so tuition's gone up, and that only shrinks access even more. Not a good picture. But I don't want to speculate because the anti-movement is driven by ideology, not facts of democratic principles of equity and access. Celebrations following the decision did not sufficiently focus on root causes, segregation and pervasive inequality of opportunity in the K-12 education systems. Recent research shows that Coleman's conclusion based on test scores does not obtain for other educational outcomes. School quality matters, and it does matter for college access. Rather, I'd like to focus, to suggest that in the post-Fisher world, universities focus more attention on the project of integration on campus, which events like such since the I Am movement a few years ago brought to light, and now magnified since all these race and ethnic tensions on campuses are rearing their heads. Imagine if the resources used to litigate admissions policies were used for student-initiated projects to capitalize on diversity by focusing on inclusion. This is the moment to change that conversation. This is what the post-Fisher conversation should be about, and no speculating about 25 years. Justice O'Connor said that the reason we're doing this is because the pathways to leadership should really represent the future of the country. Thank you.
Good morning, everyone. Thanks to Anne and Stella for making sure that we're going to have this important discussion and for organizing this wonderful event. And for the rainy weather that, this is the best place to be in today. The Supreme Court ruling that colleges can continue and use race and ethnicity in their admission decision is good news because race-conscious admissions are very successful in diversifying the demographics of elite colleges and universities. Yet, in the last decades, socioeconomic status became a pivotal contour of inequality in educational attainment. Despite this trend, most colleges have not widened their view of diversity and continue to focus mostly on race and ethnicity. As a result, the representation of underprivileged youth at selective colleges has declined steadily since the 1970s. Today, students from the bottom quartile of the socioeconomic distribution occupy less than 6% of the seats at elite schools. Surely, this is one of the reasons for the discontent with race-conscious admissions. In a recent Gallup poll just conducted last month, 65% of respondents disapprove of the Supreme Court decision in the Fisher case. 63% said that race and ethnicity should not be a factor in admission decision. Only 40% had such a negative feelings toward using socioeconomic status as a factor in admission decisions. So university leaders should see the court ruling as an opportunity to adopt a broader perspective of diversity that will make them inclusive for students from all walks of life. But how? What would be a good direction? What factor should be considered in the admission decision? We often hear the argument that race-neutral, class-based affirmative action, which would give socioeconomically underprivileged an edge in admission if implemented instead of race-conscious admission, could achieve socioeconomic diversity as well as demographic and racial and ethnic diversity. In other words, the claim is that race-neutral, class-based admission, affirmative action, can achieve broad diversity. This message is simple, catchy, and it feels right because of the correlation between race, class, and space. That is, minorities are more likely to be poor and reside in poor places. But how do we know whether class-based affirmative action can achieve the goal of broad diversity? With the exception of sporadic experiments, class-based affirmative action has never been implemented in the United States. Several other countries around the world also have affirmative action programs like India, South Africa, Malaysia, and New Zealand. But in all of them, they all use the same model as similar to the race-conscious admissions. They focus on either race and ethnicity of the applicants or their caste, so we don't get examples from these places. The first country to implement class-based, race-neutral, class-based affirmative action on a large scale is Israel. And therefore, it provides us with a unique opportunity to study the various effects of such a policy on various outcomes. So the affirmative action program in Israel was adopted in the mid-2000s by the top 4 universities in Israel, and its design is quite innovative. It is class-based because it targets disadvantaged applicants. But it is need-blind because the applicant's financial situation is not considered for eligibility. The focus is rather on the structural determinants of disadvantage, specifically coming from a poor neighborhood and a poor high school. Although other individual hardships are considered, for example, having a chronic illness or parents' high education level or their unemployment status, but the focus is on high school and neighborhood. The program, as I mentioned, is race neutral, or I should say, in the case of Israel, it's ethnic neutral because it doesn't consider the applicant's ethnicity for eligibility. In the analysis I done for my book, Race, Class, and Affirmative Action, I used the United States as a case study for race-based affirmative action, and Israel as a case study for class-based affirmative action. For each country, I compared the model that has actually been implemented to the road not taken, to the alternative policy type. So I'm not comparing Israel to the United States, but rather I juxtapose 2 variants of affirmative action, race and class, in each country. And I compare these 2 policies in each country in terms of diversity, mobility dividends, academic standing, and feasibility. For the Israeli case, I compare the actual class-based affirmative action in place to a simulated model of ethnic affirmative action. That is, if the slots that were granted to affirmative action admits under the current scheme would have been allocated to ethnic minorities in Israel, specifically Arabs and Mizrahi Jews, the two ethnic groups at the bottom of the socioeconomic ladder in Israel. For the American case, I put up race-based policies up against several simulated models of class-based affirmative action. The first model focuses on individual socioeconomic status, namely family income, wealth, and a parent's education level. The second model targets applicants in poor school, that is focusing on the structural determinants of disadvantage, and it's focusing only on group membership with school. And in that respect, it's very similar to race-based affirmative action, which also focuses on group membership. In the third model, eligibility is determined by both individual and school disadvantages. So what do the evidence tell us about diversity? The findings from the two countries demonstrate that there is no silver bullet in affirmative action policy, no one prototype. Neither the race-based model nor any of the class-based models is especially well suited for creating broad diversity. This is because the overlap between class, racial, and spatial inequality in the pool of high-achieving college-bound students is not very high. Most of the poor students who meet the academic standards of elite colleges are white, have college-educated parents, and they do not went to a poor high school. Race-based affirmative action is very successful in generating racial and ethnic diversity and widening the path for mobility for minority students. But underprivileged white and Asians are left behind. So race is not a good proxy for class. If we shift to a class-based policy, it will promote underprivileged youth and give them a boost and give a huge boost to a much-needed socioeconomic diversity at elite institutions. But there is going to be a decline in the share of minorities at elite institutions. So socioeconomic status is not a good proxy for race and ethnicity. So the focus on one aspect of disadvantage limits the potential of tapping into other aspects. The expectation that we can have one tool to create broad diversity is an illusion. So how do we move forward? The first and most essential step is to change the way we think about affirmative action. While we in the US are obsessed with the dichotomy between race and class-based affirmative action, other countries see affirmative action as a spectrum. While we think about rigid prototypes of race-based and class-based affirmative action, other countries are implementing hybrid designs of affirmative action as they target multiple indicators simultaneously. And finally, while we consider complex designs of race-based affirmative action, other countries keep their program simple and feasible. Let me give you two examples of such hybrid and simple designs of affirmative action. The first example, actually, is Israel. It's hybrid because it targets multiple indicators simultaneously. So, like race-based affirmative action in the United States, eligibility is based, as I mentioned, mostly on group membership with schools and with neighborhoods. But it also considers the individual characteristics, including socioeconomic status and other adverse circumstances. So while it targets multiple characteristics, it ensures feasibility by focusing on two indicators for group memberships. The second example of a hybrid design is Brazil's new class-based affirmative action, known as the Law of Social Quotas, which was enacted in 2012. So the Brazilian program is structure-based because public universities, which in Brazil are the more selective institutions, are required to reserve at least half of their slots for students from public high schools. The program is also need-sensitive because half of these reserved slots go to low-income students. The allocations of all of these reserved slots must match the racial makeup of each state. So the program is also race-sensitive. This is a hybrid design because it embeds the consideration of race within class-based affirmative action, focusing on high school type, family income, and race simultaneously. Like the Israeli program, however, simplicity and feasibility are achieved by focusing on two indicators for group membership, high schools and race. We should start thinking along these lines in the United States as well. One promising option, and there are many options, and what I want to do today is to start this discussion, but I'm going to talk about two possible options. So one possible option is to integrate race and ethnicity as an element in a class-based affirmative action, similar to the Brazilian concept, without the quotas and everything else. So in my study, I tested this hybrid design. Blacks and Hispanics in the pool of students who would be eligible for class-based affirmative action would get an additional small edge in admission. So this way, only underprivileged minorities get an edge in admission, while underprivileged white and Asian applicants benefit as well. The results predict that in this scheme, the decline of racial and ethnic diversity is the smallest among all other options that I've mentioned, while the level of socioeconomic diversity will get a substantial boost. But this comes at the price of abandoning race neutrality. Yet there is also a way that will allow institutions to have both broad diversity in their student body and race neutrality in their admission practices. If elite institutions substitute all kinds of preferences, including legacies, preferences for athletes, as well for wealthy students and minority, with race-neutral class-based affirmative action, they can achieve broad diversity. Under this bold reform, the current level of racial and ethnic diversity is maintained, similar to the level that we have right now with race-conscious admissions, while there is a significant boost to socioeconomic and geographic diversity at elite institutions. Yet, given how deeply institutionalized preferences are in the, like legacies, in the culture of elite institutions, and given the reliance on donation money, it's very unlikely that such a reform will take place in the near future. If so, then a race-sensitive, class-based affirmative action is required in order to boost socioeconomic diversity and approach, not maintain, but just approach, the level of racial and ethnic diversity at elite schools. So I see the court's ruling as an opportunity to have a serious discussion about how to reform affirmative action in college admission. The search after a hybrid and feasible designs of affirmative action should start by removing the smokescreen around the concept of diversity. Through this process, we have to ask ourselves several complicated questions. The first question is, what is the rationale behind implementing affirmative action policy in elite colleges and universities? why do we need it? And what do we want to achieve? Do we want to remedy past inequality or current inequality, or remedy past discrimination? Do we want to promote equal opportunity, or do we want to boost diversity? And rationale is important because arguing before the Supreme Court is really dependent on why we want this policy and what it's supposed to achieve. The second question is, what are the most desirable diversity outcomes for our society? Third, what aspects of diversity are most conducive for enhancing the educational process and students' tolerance to a wide range of viewpoints? Is race and ethnicity important in creating such diversity? So the question is whether we should or still need to consider race and ethnicity as a factor in admission decision is very critical in this discussion. And finally, maybe the most important question is, are we willing to pay the price associated with the chosen solution? This is an important question because trade-offs are unavoidable in affirmative action and diversity. So the answer to these questions will help social scientists, policymakers, and university leaders design an admission policy that is attuned to the most pressing societal concerns about inequality, while also fulfilling the educational missions of elite institutions. It's a big challenge, I know, but it's surely worthwhile investment in our future. Thank you.
Good morning. Buenos dias. Well, I wore my biggest heels today, so I hope that you can see me. So excited to be here today, and really excited to have such a wonderful group with us on this important day. Okay, well, let me start off with a story. This summer, I had the good fortune of spending nearly a month in Australia under a fellowship called Transforming Human Societies, where I was working on a project called Global College Equity with my colleague Andrew Harvey at La Trobe University. I spent valuable time with researchers, including Aboriginal scholars and practitioners interested in finding interventions to increase college access for underserved communities. Two events are reshaping my thinking upon my return. And the first involved the consistent remarks about being Black in the United States, especially today. How stories of police brutality, Black Lives Matter, and general racial strife were making the U.S. a place where people of color from other countries were unsure about living here in the U.S. A number of mothers remarked how they would not want to raise their Black sons in the United States today. The second challenge came from some Australian colleagues who genuinely asked why I thought the American dream was still possible if social mobility evidence on income inequality said otherwise. My general response was that yes, income inequality has widened. However, inequality cannot be defined by income alone, and to do so is to leave out some of the most American parts of our story, race and immigration status. I came back reflecting on where we are as a country and in our capacity, what is our capacity to provide genuine educational opportunity for all students. So my question today and my presentation is focused on the following question. Is our favorite story of the American dream still present, or are other countries doing better? As the daughter of an immigrant mother turned educational researcher, I would say the evidence is still on our side, but I do encourage us to constantly explore the following. I don't know if the PowerPoint is up. Okay. I'm not able to see. There you go. So it's not there, so I'm going to roll with it. It'll be fine. It's just right behind. Nope. It's on the desktop, okay. All right. I'm prepared to do both, but I apologize for the interruption here. Okay, great. How far have we come, really, and where do we need to go? And this has come up from the other speakers. So let me begin with some of our uncomfortable history. Historian James Anderson reminds us that higher education in the U.S. evolved in parallel to a system of slavery and other supremacy ideologies relating to race and class subordination. As American universities developed, European scholarship espousing the innate superiority of whites was widely read by American intellectuals and politicians. These ideas translated into how the construction and operation of U.S. schools and colleges and universities were to be. In addition, law and policy for a time formally supported these ideals and played out in the access and opportunity of students and their educational outcomes. In essence, these ideas translated into American law and policy and various aspects of civil life, including transportation, employment, education, marriage, and where one could use the restroom. Michael Olivas describes the next era of the university as one that was determined to protect the power of white spaces. Here we saw states supported by northern missionary groups to erect black colleges, what we call historically black colleges and universities today, including law schools. In states with no black colleges or curriculum at these colleges, states paid for scholarships for blacks to attend colleges and universities in other states. And we heard our own dean talk about that this morning. Many came to New York and many came to NYU. Other options, including the roping off of areas or providing separate classrooms in white colleges for blacks to sit in. Similar strategies were employed in the Southwest for Latinos. While I will leave the legal history and interpretation to my esteemed panelists in the room, I emphasize that from an educational research and policy perspective, we have undergone what I call 3 areas of the slow pathway opportunity definition. The first has to do with the separate but equal cases and the understanding of the harmful effects of legal segregation. These include the cases such as Plessis v. Ferguson, Sweat v. Painter, and Brown versus Board of Education. In 1978, we moved into the era of the quota and educational benefits of diversity cases, beginning with the Regents of the University of California versus Bakke and the Gratz and Gretter cases. And the third area, which I've spent much of my career on, has to do with the validity of race-neutral research, mostly through the percent plans in Texas, but how this research compares to admissions programs that employed more holistic reviews that use race as one factor of consideration. So where are we now? Part of my responsibility is not only to produce research, but translate the research not only to students, but also institutions and policymakers. And the research takeaways are the following. Am I in the right space? Yes. Segregation in schools is significantly harmful to student outcomes in regard to cognitive gains and test scores, particularly for black students, but also Latino students. In our research in Texas, we found that the variable most responsible for explaining the racial college completion gap has to do with high school segregation. That is, while other variables contribute to this gap, such as academic preparation and economic disadvantage, it is the concentrated disadvantage, a term I learned from Marta Tienda, that is present in racially segregated high schools that has negative effects on the long-term educational outcomes, such as college enrollment and completion. It doesn't stop at test scores. A second part of this research takeaway is that there are educational benefits of diversity to students broadly, a fact that the court recognized in their decision. And these benefits include cognitive gains, reduction in stereotypes and prejudice, and improvements in critical thinking and problem-solving skills. A diverse environment also is documented to improve intergroup contact and cross-racial interactions, a skill we need to deeply continue developing as a nation, especially in these troubled times. Finally, race-neutral programming, such as the consideration of class without race, is not a more effective alternative in increasing racial diversity than the use of race as one factor of consideration. And multidisciplinary studies have shown this, another fact that was documented in the court decision by Justice Kennedy. So where are we going in the future? What considerations should we be conscious of? The first is that affirmative action bans continue in 8 states and many other institutions, and their effects have crossed state boundaries. 8 states, some of which are the most demographically diverse in the nation, are essentially unaffected by the Fisher decision in that state bans on affirmative action remain the common practice without additional legislative action. Declines in minority enrollment are also no longer relegated to state jurisdiction. Drops in race and ethnic diversity of a student body transcend state policy boundaries given the interdependent market of college admissions, something Mark Long and colleagues have found in their research. At the federal level, we have growing interconnection between K through 12 and higher education outcomes, and this is going to be especially so with the new Every Student Succeeds Act, a federal act recently passed in December of 2015. What is happening is the convergence of K through 12 and higher ed, in that states are now responsible or have more responsibility in designing K through 12 systems that prepare students for their own colleges within that state, college and career readiness. What this means is that states will have an increasing role in shaping educational opportunity from kindergarten through the end of college and graduate school, but not only shaping opportunity, but also reducing inequality. States have now have, or always have had, but in particular with a focus, a responsibility to know the status of their own inequality and mechanisms that exacerbate this. This is essential because state outcomes contribute to the overall health of the nation. Finally, if you know me, you know I'm always going to talk about data and the need for better data. We need identification of effective equity policies, but this will require the use of strong data systems. Development in data quality and evaluation methods can allow for better construction of educational equity policies. We need better data to understand how to formulate better interventions. But I will say that institutions and states shouldn't do this on their own, and this is work that Catherine Horn and I have written about together. It is important for states to understand and forecast their own institutional context, specifically how their demography is changing. We recommend creating stakeholder teams for data assessment and college success within a state. Again, for institutions that are lower resourced, it's going to be harder for them to do this, so therefore forming state partnerships, local partnerships, will be essential for this strategy. Finally, we need to recognize that strategies for reducing inequality will vary across state contexts due to the environment of state and local policies, and thus will require multi-jurisdictional solutions to make substantive change. Let me close with this. Winning the Fisher case was a necessary and phenomenal outcome, but it's also an insufficient strategy for reducing inequality in schools and higher education. The use of race in college admissions as a factor of consideration will not on its own dramatically reduce all inequalities based on race, class, or immigration status. However, retracting the use of race nationally would have been a dramatic step backwards in educational opportunity and a big step toward increasing racial and ethnic inequality in schools and society. The world is watching, and we can't afford to get it wrong. This is not a metric for which we should not lose standing. If we have, we need to remedy it quite quickly. We have to get it right. Our history demands so, and frankly, we have no excuse to not get it right. Thank you.